You know, sometimes in politics and law, it's the smallest details that bring down the biggest figures. And what I'm about to tell you about Trump's latest legal nightmare will shock you, not because of its complexity, but because of how simple and avoidable it was. Yet here we are, watching it spiral into something that could change everything. The Ballroom case. That's what legal insiders are calling it now. And if you haven't heard about this yet, you're about to understand why Trump's legal team is having sleepless nights and why this seemingly minor dispute has the potential to unravel much more than anyone anticipated. Let me paint you a picture of how this all started because the origin story will tell you everything you need to know about why this case is different from all the others. It wasn't a raid, it wasn't a grand jury, it wasn't even a formal investigation. It started with a wedding reception gone wrong and a billionaire's ego that couldn't let go of a $47,000 dispute. But here's what nobody saw coming. That wedding reception would become the key that unlocks a Pandora's box of financial records, business practices, and legal vulnerabilities that Trump's lawyers have spent years trying to keep sealed. Sometimes the smallest crack brings down the entire dam. The case began 18 months ago when a wealthy New York family hired Mar-a-Lago for their daughter's wedding reception. Premium package, top shelf everything, guest list that read like a who's who of Manhattan society. Everything went perfectly until the final bill arrived, and that's where this story takes its first unexpected turn. According to court documents filed in Palm Beach County, the family disputed charges for what they claimed were unauthorized upgrades and services they never requested. We're talking about gold-plated flatware instead of silver, imported flowers instead of local arrangements, premium liquor substitutions that nobody approved. The additional charges, $47,000. Now, for most business disputes of this size, you'd expect a quiet settlement, maybe some back and forth between lawyers, everyone moves on with their lives. But Trump doesn't do quiet settlements when he believes his reputation is on the line. And that decision to fight over $47,000 is now threatening to cost him millions in legal exposure. The family's attorney, Sarah Martinez, a former federal prosecutor with a reputation for thoroughness, filed what initially appeared to be a simple breach of contract lawsuit. But Martinez did something that Trump's legal team apparently didn't anticipate. She requested full financial disclosure of Mar-a-Lago's pricing structures, vendor relationships, and billing practices to prove that her clients were systematically overcharged. That's when this case stopped being about wedding reception bills and started being about something much bigger. Because when you demand financial transparency from Trump Organization properties, you're not just asking about one event, you're asking about patterns, practices, and potentially years of business operations. Here's where the legal nightmare really begins. To defend against allegations of systematic overcharging, Trump's lawyers had three options: settle quietly and admit no wrongdoing, fight the case and risk broader financial disclosure, or claim the lawsuit was politically motivated harassment. Guess which option Trump chose? Trump instructed his legal team to fight, claiming that this was just another politically motivated attack disguised as a business dispute. But that decision opened a door that his lawyers desperately wanted to keep closed, the door to discovery, where opposing attorneys can demand documents, records, and testimony under oath. The discovery requests in this case are a prosecutor's dream and a defendant's nightmare. Martinez's team is asking for 5 years of Mar-a-Lago billing records, vendor contracts, markup policies, guest complaint files, and staff communications about pricing decisions. But it gets worse. They're also requesting Trump's personal involvement in pricing approval for high-profile events. I've seen this pattern before during my own legal challenges. Sometimes the cover-up becomes bigger than the crime, and sometimes the small fight reveals vulnerabilities you never knew existed. Trump's decision to turn a $47,000 billing dispute into a federal case is now exposing business practices that have been hidden for years. According to legal sources familiar with the case, the financial records being requested could reveal patterns that extend far beyond wedding reception pricing. We're potentially talking about tax reporting discrepancies, insurance claim irregularities, and vendor relationship arrangements that might interest other investigators. But here's the part that should worry Trump most. This isn't a criminal investigation where he can claim executive privilege or political prosecution. This is a civil business dispute where normal discovery rules apply, and where his status as a former president provides no special protection. The timing couldn't be worse for Trump's broader legal strategy. His lawyers are already juggling multiple criminal cases, civil lawsuits, and regulatory investigations. Adding discovery obligations from a business dispute creates resource strain and potential contradiction risks across all his legal fronts. Legal experts I've spoken with say the Ballroom case creates what they call discovery overlap risk. Information revealed in this civil case could potentially be used by prosecutors in criminal matters, by regulators in compliance investigations, or by other civil plaintiffs in related lawsuits. For example, if the discovery process reveals that Mar-a-Lago systematically inflated charges for events, that information could be relevant to tax investigations, insurance fraud claims, or consumer protection violations. One case starts feeding into others, creating a web of legal exposure that becomes increasingly difficult to manage. Here's what makes this particularly dangerous for Trump. The plaintiff family has significant resources and no apparent political motivation. They're not trying to take down a former president. They just want their $47,000 back and proof that they weren't systematically deceived. That makes them a more credible opponent than politically motivated prosecutors in the eyes of many judges. The family's lead attorney has already indicated that they're willing to take this case all the way to trial if necessary. They believe they have evidence of systematic overcharging that goes beyond their specific event, and they want that evidence to be part of the public record. Trump's legal team is now caught between several bad options. They can continue fighting and risk massive disclosure of sensitive financial information. They can settle for far more than the original $47,000 to make the case go away, which sets a precedent for future similar lawsuits. Or they can try procedural maneuvers to delay discovery, which creates appearance problems and adds to legal costs. Meanwhile, the case is attracting attention from other potentially affected parties. Other families who held events at Mar-a-Lago are reportedly reviewing their bills and considering their own legal options. Consumer protection agencies are monitoring the case for potential enforcement opportunities, and investigative journalists are preparing to scrutinize whatever financial information becomes public. The psychological impact on Trump shouldn't be underestimated either. This case strikes at the heart of his business reputation and challenges his image as a successful deal-maker. The idea that a family from New York could expose his business practices over a wedding reception bill is exactly the kind of humiliation that tends to trigger Trump's most self-destructive impulses. I've watched Trump long enough to know that he tends to escalate rather than de-escalate when he feels his reputation is under attack. That tendency has already turned a minor billing dispute into a major legal liability, and it could easily make things even worse as the case progresses. The broader implications extend beyond Trump personally. If this case establishes that Trump Organization properties engaged in systematic overcharging, it could trigger a wave of similar lawsuits from other customers. It could also attract regulatory attention from consumer protection agencies and state attorneys general. There's also the political dimension to consider. While this case isn't explicitly political, it's happening at a time when Trump is trying to project strength and business competence for his political comeback. Getting bogged down in a messy business dispute over wedding reception bills doesn't exactly convey the image of a successful executive. The discovery timeline in this case could also create political complications. If major financial disclosures are required during primary campaign season, it could provide opposition research material for political opponents or distract from Trump's campaign messaging. Looking ahead, this case represents a new category of legal vulnerability for Trump, the unforced error that creates cascading problems. Unlike the criminal cases, which he can characterize as political persecution, this is a straightforward business dispute that he chose to escalate into a major legal battle. The lesson here is one that every business leader should understand. Sometimes the cost of being right is higher than the cost of being wrong. Trump's decision to fight over $47,000 has already cost him far more in legal fees, and the potential exposure from discovery could cost him much more in the future. As this Ballroom case continues to unfold, It's becoming clear that Trump's legal troubles aren't just about the high profile criminal cases we hear about every day. Sometimes the most dangerous legal problems are the ones that seem minor at first but reveal much larger vulnerabilities upon closer examination. The wedding reception that started this whole mess was supposed to be a celebration. Instead, it's become another front in Trump's expanding legal war, with consequences that nobody could have predicted when the first bill arrived in that Palm Beach mansion.